Okay, cool.
Yeah.
All right, I think we're live here, Mike.
All right.
Let me just start off by saying hi, everyone. Welcome to the live stream. My name is Mark Nolan. I'm the COO at Hint Health. As you may know, we at Hint are always looking for opportunities to bring potentially valuable information to our clients' attention. And today, along that stream, we're going to talk about the Employee Retention Credit, or ERC, and what you need to know about it for your practice. If you have any questions, comments as we go along, please add them in the comments area, and we'll aim to address them all during this live stream. So with that, I'm delighted to be joined here by Mike Mitchell. He is the Chief Legal Officer at Stenson, Tamaddon. He is well positioned to guide us through this topic. Welcome, Mike. Thanks for joining us here today.
Mark, thank you for having me. I appreciate the opportunity to be here and to discuss this with your clients.
Yeah, no, thank you. How about let's start off if you could tell us a little bit about yourself and about Stenson Tamaddon.
Sure. My name is Mike Mitchell. Obviously, I'm the Chief Legal Officer at Stenson Tamaddon. I've been here since September of 2022. Prior to that, I was doing tax litigation controversy at a private specialty tax litigation firm in Scottsdale, Arizona. And prior to that, I was a special assistant county attorney at the Maricopa County Attorney's Office and an assistant attorney general at the Arizona Attorney General's Office. And one of my focuses in private practice was doing the ERC for our clients, and we had many clients, and I moved into an in-house position here in September of 2022. Stenson Tamaddon is a unique firm as far as the employee retention credit goes. We're unique because we were started roughly in 2020, just before COVID-19 swept through the United States. And what happened was our CEO, Eric Stenson, who is a software developer, a technology expert at heart, he developed a product for the PPP loans and PPP forgiveness applications, a software product to facilitate businesses getting those and then getting forgiveness of those loans. While he was doing that, he learned about the employee retention credit, and he developed a proprietary software product to produce the calculations in accordance with IRS guidance to generate the 941Xs, which are how you amend your employment tax returns and claim this credit. And so we had a lot of success early on as a firm because we had a great network of referral partners, CPA firms, all kinds of different referral partners that we worked with for PPP, whose clients were then interested in and qualifying for ERC. And so we've processed thousands of claims at this point in time. And we produce consistently accurate calculations due to our generator in accordance with IRS guidance.
Okay, so you and your firm are clearly the ones for us to be talking to about this topic. There's a lot of buzz about this topic. You know, I myself have seen it in news articles and even been, received emails around it. Can you tell us just in general, what's this program all about? Where'd it come from?
Absolutely. Yeah, it's really important to kind of discuss where it did actually come from, which is federal law. All right. So in March 2020, and I like to do this when we talk about this, but it's really important now that we're at March 2023, almost starting tomorrow, I guess. that we take ourselves back to March 1st of 2020, 3 years in time, and remember kind of all the uncertainty, the anxiety that was going on at that time. States were starting to shut down, schools were starting to shut across the country. So there were a lot of things going on, and a lot of those things we kind of remember, but we need to take ourselves back. And so in response, in mid-March of 2020, the United States Congress passed what's called the CARES Act of 2020. And that was the basis, that was the federal law that authorized things like PPP loans, for example. It also authorized the employee retention credit. And so what the initial federal law did was it authorized $5,000 per W-2 employee for 2020. And you could claim that in advance or retroactively. Obviously, if you're thinking about it now, it would be a retroactive claim. So the advance aspect of the law has passed. And so that was $5,000 for the entire per employee on $10,000 of qualified wages for the entire year of 2020. Now, importantly, because you see a lot of stuff in the media about the ERC, but that wasn't the only time that this credit was passed into federal law. So March 2020 was the first time. Since then, you had the Relief Act pass, same Congress, same president, December of 2020. And that actually extended the credit, and it made some changes retroactively. One of the important changes it made retroactively was the fact that if you received PPP, which is very popular and easy to obtain following the CARES Act, and that's where most businesses went first, that was the first stop for relief for most businesses. It said you can use both ERC and PPP, but you can't double dip. So, for example, if you received PPP, you paid wages of your employees with PPP, which is federal funds from the SBA. You have to back that amount out when you claim the ERC. So you can't use the wages paid with federal funds to get a federal tax credit, right? So the Relief Act amended it, extended it. Then new president, new Congress in 2021, the American Rescue Plan extends it further and actually makes some changes to the credit, which basically it says, okay, now you can get for 2021, you get $7,000 per employee per quarter, up to $10,000 in wages per quarter. And initially, the rescue plan had the credit running through the end of 2021, but subsequently in November of 21, the Infrastructure and Investment Jobs Act rolled it back for most businesses to September 30th. So just the first 3 quarters of 2021. But it's $7,000 credit per W-2 employee on the first $10,000 of wages per quarter. And so I just bring these up because I think there's a real important thing here, which is that 2 different presidents, 2 different Congresses passed this credit multiple times into law, and they extended and amended it. So there's overwhelming amount of evidence that the United States Congress wants businesses to claim this credit for relief. And what was the point of the credit? The point of the credit was this. Again, take ourselves back to March 2020. We didn't know what was going to happen to the economy when COVID swept through everything, right? And so the idea was, well, people are going to need health insurance more than ever, and people are going to still need paychecks even if we have to close everything down. How can we continue to do that? And the ERC and PPP were part of the plan to keep small, medium-sized businesses operational, to keep employees on the payroll, even if they were fully or partially suspended by government COVID orders, and to keep providing their employees with health insurance if they offered that.
I'm going to ask you about some specifics on the program in a second, but based on what you said, is it fair to say that there's a window for those who can apply for this, who are eligible for it? That window is closing, and it closes with the upcoming tax season. Is that a fair statement?
It's a little complicated, but roughly yes, in terms of Form 941 is the employment tax form, if you have W-2 employees, that almost every, with certain exceptions, employers are required to file. And that's usually filed quarterly. That's where you pay your employment taxes. And so the way the IRS statute is, you have 3 years from the time you've originally filed your 941 to file an amendment. Now, IRS guidance deems all of the 941s filed for a particular year as filed on or before April 15th of the following year. So, for example, when we're talking about your 2020 941s, the IRS, even though they're due quarterly in 2020, the IRS will deem them all filed and due April 15th of 2021. So if you do 3 years from that, that brings you to April 15th of 2024. Similarly, since the credit's only available for calendar years 2020 and 2021, then you have a deadline for 2021 of April 15th, 2025, roughly. It could actually be a little bit before then, but I don't want to get too technical on folks on how that works.
Okay, no, thanks for going down that route. So it sounds as though employers need to qualify for the program. What does qualify mean? Can you talk about the guidelines? How should people be thinking about whether they are likely a good candidate for this or not?
Sure. Well, there's a lot of criteria that goes into it. It's pretty complex credit. So there are a couple things I'm going to go over on it. The first, I'm going to talk first about the objective criteria, and then I'm going to talk about the subjective criteria. So one of the first things you have to do is have a business. All right. You have to have operated a trade or business with W-2 employees during 2020 and 2021, or at least one of those 2 years. Right. So that would be and typically, right, you do that if you filed 941s, you have an EIN. So you've met that criteria. One of the big things, and I'm not going to get too much into it because I don't think with the folks we're speaking here today, which I understand are healthcare practices, that it's exceptionally common with them, but there's a thing called aggregation. So for the aggregation principles and rules apply to this credit. And so that basically means that when we look at some of the criteria involved in the credit, we need to make sure, okay, do you own multiple companies with W-2 employees? If you do, we have to aggregate all of those in terms of their gross receipts and the number of full-time employees to see where a business lands in terms of this criteria on the initial criteria. So that's aggregation. Something we need to know up front from business owners is, what businesses do you own in addition to the one that's interested in claiming the ERC? How many employees do each W-2 employees do each of the businesses have, and what's the total number? And the reason we know that is because the objective criteria for this credit is it measures based on 2019. So 2019 is an important year for everyone here to remember. The reason 2019 is important with this credit is because it was the last normal year for businesses in terms of they weren't affected by COVID, right? So that's the baseline year for this credit. And the statute basically requires certain full-time employee limits in 2019 in order to qualify for 2020 and 2021. So for example, if you had less than 100 full-time employees on average per month in 2019, then you are a small eligible employer who may be eligible to claim the credit in 2020. As I mentioned, the subsequent legislation changed it for 2021, increased the threshold. but still use the 2019 baseline year. So on average per month, if you had less than 500 full-time employees in 2019, then you are a small eligible employer who may be eligible to claim the credit in 2021 if you meet other criteria. So aggregation and the full-time employee count, and by the way, very important principle here, similar to the healthcare law, federal healthcare laws, right? Full-time employee means 30 hours per week or more for purposes of this credit, all right? Also 130 hours is an alternative, but most common is 30 hours per week or more to determine the number of full-time employees on average per month. And again, for 2020, it would have needed to be less than 100 on average per month full-time, and 500 or less for 2021. Now, getting through go ahead and we'll go to another question. So those are kind of initial threshold criteria that any provider or that any business owner needs to look at before you would try and claim this credit.
Yeah, one minor question on that. The type of business, does that matter if they're an LLC versus a professional corp versus a C corp? Does that matter?
No, the type of business does not matter in terms of, right? Basically, if you're an LLC, you're taxed as an S corp, a C corp. If you're an LLC, taxed as an S corp, partnership, or even a disregarded entity, as long as you have W-2 employees, you might be eligible to claim this credit. Similarly, a C corp could claim this credit as well. If you're a single member LLC, you're likely not eligible to claim this credit, right? You have to have W-2 employees.
Yep. So you mentioned there are objective criteria, and then you brought up something subjective criteria, I think you said as well.
Yeah.
What did you mean?
Let me just correct the single member LLC.
Yeah.
If you're a single member LLC and you only have yourself as an employee and your relatives, that would not be a basis for claiming this. But if you're a single member LLC with W-2 employees, you could claim. So I'm sorry, go ahead with your question.
Just curious, you had mentioned subjective criteria in addition to the objective ones. What did you mean by that?
Yes, right. So when we get to the statute, we talked about the objective criteria in terms of aggregation. We talked about the objective criteria in terms of full-time employee counts. There's one more objective criteria that could be a basis for qualifying under the statute. And again, that uses 2019 as the baseline year, and it takes the gross receipts of that business from 2019 and it compares them to 2020 and 2021. And so, for example, if you had gross receipts, and we'll just go calendar quarter to calendar quarter, assume a fairly large business. If you had $1 million in gross receipts, I'm going to use really easy numbers so I don't make mistakes. In 2019 for a calendar quarter, and that corresponding quarter in 2020, you had 500,000 in gross receipts or less. Well, then you would be objectively eligible for the, if you met the other criteria, you would be objectively eligible to claim the ERC based on a decline in gross receipts of 50% between 2019 and 2020. And that would be your basis for claiming it. In 2021, the threshold's a little different, a little more generous. We still use 2019. We're still sticking with the 1 million in gross receipts for a calendar quarter in 2019. Corresponding quarter in 2021 is 800,000 or less in gross receipts. Then you would qualify because you meet that 20% decline threshold in gross receipts from 2019 to 2021. It's a little counterintuitive because, again, 2020, it was a 50% threshold of 50% decline, 2021, 20% decline. All right. And that's objective. Now you asked about subjective.
Yeah.
What a lot of folks, when they initially looked at this credit, only read the objective criteria. which is the gross receipt decline. And that's in federal law. That's statutory language, right? But there's also in federal law a very important connector, and it's not an and, it's an or. So it said gross receipt decline, or your business operations were fully or partially suspended by governmental COVID orders that limited commerce, travel, group meetings, etc. That is what you call the subjective part of the statute. Okay. And that's where a lot of businesses may be a basis for a lot of businesses that didn't have the 50 or 20% decline in gross receipts to make a reasonable case, a good faith claim for this credit. And the way that works is this. One of the easiest ways to explain that subjective part of the statute, the full or partial suspension due to government COVID orders, I think is the example of a restaurant or a bar. And so those businesses remained open virtually in every state throughout the pandemic. They were never fully shut down, right? But a lot of restaurants and bars have large indoor dining rooms that made up a substantial portion of their revenue. Those large indoor dining rooms almost universally were suspended for a period of time in 2020 mainly, by the way, by state orders from governors or the state health department, since the federal government really doesn't regulate indoor dining at bars and restaurants, right? And so they suffered a partial suspension due to government COVID orders. They weren't allowed to open their indoor dining for a period of time at all. And then when they were allowed to reopen in most states, it was only a partial capacity. So it started maybe at 25% in some states, then at 50, right? And depending on where you were, and I'll give you an example, it depends on how long that suspension, right? Some states, they lifted those suspensions earlier than other states, but I know I went to Hawaii on a vacation in October of 2021, and they still had severe restrictions on bars and restaurants in Hawaii when I was there. So, that extended past the September 30th. Kind of a different example in the medical area is that almost universally, remember, everyone was concerned, hey, how are we going to have enough PPE, right, which is, healthcare protective equipment to care for COVID patients. And so there was actually a national PPE conservation and management strategy from the federal government. And almost every governor put a ban on elective surgeries for a year or longer during COVID in order to conserve healthcare resources.
Is the business operations fully or partly suspended because of COVID? Does that have to relate to a government, and it sounds like in almost every case it'd be a state action, or is there a discretionary aspect of it? So I'm a primary care practice, and I actually just saw patients virtually during this period rather than seeing in person, given, a multitude of things maybe going on. Maybe my staff couldn't come in, maybe they were sick with COVID, et cetera. Is there a discretionary aspect of, my business was impacted by this, not necessarily because of a state order, that limited it?
Sure. The statute's very clear that there needs to be a governmental order in effect, right? But one of the things is the primary government orders do come from the state level in most cases, right? But then, for example, there's other government orders, and I'll give you an example, like nursing homes, long-term care facilities. In the medical industry, there's actually more federal regulations that apply depending on certain payments that you may accept, right? And so CMS, for example, might restrict you if you receive Medicare or Medicaid payments and you treat those patients. you may have to uphold the standards that they prescribed in order to receive those payments. And CMS, for example, it regulated access almost directly to a lot of residential long-term care facilities all the way through the end of 2021. And it had these restrictions that they had to meet in order to continue receiving funding for those patients that were federally funded. But also county health departments, state health departments, cities, even in large cities, those were additional restrictions on particularly healthcare providers. Most counties have a healthcare department. All states have healthcare departments. And so they do some regulation. In some of the bigger cities, they even have a healthcare department. And obviously the doctors in a particular state are subject to a lot of state regulation, may also be subject to federal regulation to a degree, depending on how the practice is. But I think to kind of more directly answer your question, you may have had to partially suspend your operations to transition from a physical diagnosis, office visit environment to a virtual environment, unless you were previously set up, right? Because obviously, there might, if you didn't have that capability prior to COVID, you didn't just flip a switch and turn it on. It might have taken you a couple months. It might have taken you 1, 2, 6 months even to get that capability up and running in some instances. And so depending on what the specifics of that, could that be a good faith basis for claiming partial suspension of business operations? The IRS guidance says it could be. A transition to virtual could be. So it's a whole facts and circumstances test. So I can't give you a blanket answer for everyone, but it's something that you have to look at, and you have to really go back 3 years and figure out what are all those things that I had to do in response to government COVID orders. One of the other things you mentioned, very important, is the quarantine rules, right? If someone was exposed, you had to quarantine. There were a lot of government orders out there. If you had a breakout in your facility, you may have had to close that for 14 days. You couldn't, and then your operations were suspended. Maybe you did, or at least partially suspended, if all you could do during those 14 days was virtual. So there is a lot there. I'll give you something that's really common and almost universal in the healthcare industry. Healthcare providers were basically universally required, either through federal, state, county, a combination thereof, to screen their staff daily for COVID symptoms and to screen all the patients daily for COVID symptoms. They had to observe 6 feet of social distancing in their weight rooms. I remember, for example, going to my dermatologist, and the dermatologists were coming out to see people in their cars rather than having them come in for certain things. Yeah. So there were, yeah,
that's helpful. I know, I can recall back to that time, a number of HINC clients were affected by it. If for no reason, they were on the front lines, and the doctors and their staff were exposed to COVID in many cases more than many of us were. So,
yes, definitely.
You've noted that there's misconceptions and myths around the program. I think you said it's a myth that I can't get this because I also got a PPP loan because of the change in the law. You noted that it's a misconception that I couldn't get this credit because I didn't have a decline in revenue, because you noted that the law states or when it comes to the business impacted by COVID. Are there any other misconceptions or myths, based on the conversations that you've had, that some people might have front of mind that you could dispel in case they actually are eligible for this?
Yeah, sure. One of the things is, if you haven't claimed it and you think you might be eligible, then you should explore it, right? So it's not too late to do it. So that's, one of the myths. Another is, right, just because you were continuing to operate doesn't automatically disqualify you from the credit. Again, it's a facts and circumstances test overall. So you have to look, outside the objective criteria. The facts and circumstances are what I go back to with the subjective analysis, right? And you have to take the totality of the facts and circumstances during COVID, look at the government COVID orders that fully or partially suspended your business, related to commerce, travel, group meetings, etc. And there were actually a lot more out there. I often talk to people every day. They think they're essential business, but when you look at the government orders, they actually weren't, right? So now healthcare practices, of course, typically universally are going to be essential businesses, and they continue to operate throughout COVID without full interruption. But, for example, if you are a practice that offered elective surgeries, in addition to what are, essential procedures, right? And again, when you drill down on a lot of these state orders, they didn't just suspend elective surgeries. They also suspended like elective and non-life threatening appointments at practices, because the idea was like, let's make sure they have all they need to combat COVID.
Makes sense. So if we turn from a bit of the background to what's the process? So I'm a practice, I'm listening to this. I wasn't aware, maybe because of some of the things you just said, that there might be an opportunity for me to be eligible for this program. What's this, how does this start? What's the process for your firm to engage with someone? What type of information, if I'm a practice, do I have to pull together for this?
Sure, absolutely. So one of the ways that you claim the credit is, well, the only way really to claim the credit is you have to amend your employment tax returns, which typically are your 941s. So one of the first things a business should do if they're considering claiming this credit, because we see this a lot, is make sure all their 941s have been filed timely. That's very important. And let me give you an example of what I mean by that. If you file, a lot of small businesses use payroll providers now. And if you use a payroll provider and you file electronically, it doesn't mean you shouldn't check up from time to time to make sure that those returns actually got there. Now with electronic returns, very, very unlikely that those were not electronically and timely filed. But again, you can always check. If you're paper filing your 941s, and we see this a lot with our clients, if you or your CPA or a bookkeeper or someone else are paper filing 941s, we often will see that a bunch of them are missing. And a client will say, oh, but I filed that. And I believe them, right? But here's what happens is that if you paper file your 941s and you don't send them certified mail every quarter to the IRS, and you don't know if they ever got there. Did the mail deliver them? Did they get lost in the mail? Does that happen? Absolutely, it happens. We see it all the time. Because we send everything via USPS certified tracking. And we see time and again, 4 out of 6 parcels will arrive at the IRS facility, get delivered. 2 will show in transit and either have to be resubmitted, or sometimes you call the IRS and they say, yeah, it's in transit, but we got it, right? So you have to check, make sure those 941s are there. Then the second thing you need, so we need a copy of the 941s. For smaller employers, under 50 full-time employees on average per month, we don't ask for a 1094C because they won't have it. But typically, if you have a 1094C, we like to ask for that. for the medium and larger employers that are eligible for this credit, because it gives us an idea of the number of full-time employees that they have and any aggregation issues, because the same rules that apply for health insurance apply in turn for those criteria apply for this credit. And we need their payroll. We need copies of any SBA loans, PPP loans, and PPP forgiveness, any other federal credits that they received. And so when we get all of those things, we can generate the 941Xs for them with the appropriate calculations that would help them claim the credit. And the IRS only accepts 941Xs on hard copy. So after those are signed, which they can be signed electronically by revenue procedures, per revenue procedures, but they do have to be mailed in via USPS certified tracking to the IRS. And then there's a lot of status updates following that.
So I work with your firm, I get you that information, it gets filed. How long am I waiting for this funds from the IRS?
So yeah, that varies, and it's not fast. So if anyone, tells you, oh, we get you your money within 30 days of filing, that would be a red flag if someone tells you that, right? But the reality is you file. It takes about 4 months for the IRS to even really get it in its system. And so it can take, up to a year or longer for some claims to process and for the refunds to be mailed to the taxpayer. Now, typically, this is what we're seeing because the IRS has publicly stated, and there's multiple documents that basically they're pre-auditing these claims. So there's different levels. So, for example, if a business is going to get $80,000 or less per quarter, after the IRS does an initial review before they issue those refunds. And because there's only one review, we tend to see those going out quicker. Those will typically are going to be paid out within 6 months of filing. It could be 4 to 6 months for those smaller amounts. Now, there are, of course, exceptions, but generally the smaller ones process quicker. When they're in 80 to 200K, then they get an initial review and a secondary review before the refunds are approved and issued to the taxpayer. So those typically will take a little longer if you're in that amount. And then when it's in 200K or more per quarter, then there's a initial review, a secondary review, and managerial review before those refunds issued. And so those are taking the longest by and large, at least minimum of 6 months, but some are 12 months or more.
So that's a long time potentially for me to wait for my credit. I think you had mentioned earlier in the call, I thought you said something about advanced funding, and I was wondering what exactly you meant by that. Is that a government thing or is that a your firm thing, and how does that work?
That's just with our firm. So our firm, some of our clients, this is something we just rolled out in 2023 for the most part, but this is due to demand from clients because they don't want to wait 12 months for their checks. So a lot of them would like to finance their claims after they file them, and they do so with us. So, for example, you can file your claim. We will advance you a portion of the claim, right? There's obviously some fees associated with that, but it can get you your money much quicker and you don't have to wait that 12 months. And we will wait the 12 months for the IRS to issue the checks and get paid back. So, that's something that we offer. There is something, though, I thought about that I really do want to touch on with everyone and want them to understand. And it's I know we're coming towards the end of our time here, but the PPP loans, if you went and you got a PPP loan and that loan was forgiven, well, the law was such that it was excluded from your gross income, meaning that you did not have to pay taxes on the amount that was forgiven. Typically you do, right? If you take a loan and the lender forgives that debt, that's income to you as the business, and you owe taxes on that. But there is a specific provision in the law with PPP that there were no taxes on the PPP forgiveness. This is not the case with ERC. ERC is taxable to the business, right? And so if you have a flow through, it's taxable to the owners. And this is what I mean by that. You claim the ERC on employment tax forms. You get these checks. Now you need to go back as the business owner and amend your tax returns, your corporate income tax returns, and possibly your individual income tax returns if it's a flow-through entity, such as an S Corp or a partnership, right? Or a LLC that's a single member LLC that flows through to the 1040. Those returns for 2020 and 2021 need to be amended because there will be income tax on the amounts received, right? But obviously it still makes a lot of financial sense to get the refunds and pay the taxes. It's just not tax-free.
Got it. That's helpful. I think the last question I had was, the IRS they're reviewing these applications, and they're clearly after the fact, as they would in all cases, there'll be some level of auditing. What's your firm's involvement if a client gets audited, after the fact? Do you guys work with them in that part, or do you give them the right documents so that they're ready for it? Can you tell us a little bit about that?
Yeah, absolutely. So in the IRS guidance, there's substantiation requirements. In fact, I think it's 70 or 71. Can't remember which one off the top of my head, but we follow those substantiation requirements and we build audit-ready compliance files for our clients as they're going through the process so that they have supporting documents available in the event that the IRS examines their claim down the road. And how long does the IRS have to examine their claim? Well, for most quarters, it's 3 years from the time the original 941 was filed, except for quarter 3 and quarter 4 of 2021, which have a 5-year statute of limitations. Now, what we do is we keep that compliance-ready file available to the client. We also have tax litigation firms that we have retained with former IRS trial attorneys that will represent clients in the event of an examination. And we will cover the cost of that representation by those well-qualified former IRS trial attorneys.
Okay. And Stenson Tamaddon support for clients, that's available in every state, is that correct?
Yes, we work we have clients in every state across the country right now, and we can process their returns.
Great, glad to hear it. I see one question from the audience is, what if the business was not started before 2021?
Yes.
Would it still qualify?
Great question. That's something we didn't fully go into, but there's a special category called recovery startup businesses. And those are businesses that began operating on or after February 15th of 2020. And they typically will have to have less than 1 million in gross receipts, but they can claim the credit as recovery startup businesses. Now, they're only eligible for 2 quarters, quarter 3 and quarter 4 of 2021. Again, it's not a coincidence that those are the quarters with the 5-year statute of limitations, right? And for those 2 quarters, a recovery startup can claim the credit. It has a cap on each quarter of $50,000. And I think the reason that those 2 quarters have a longer statute of limitations is because of the recovery startups. right? Because for most businesses claiming this credit, they have a long track record of 941s. 2019, 2018, they were in operation well before this law was passed, right? And so the IRS can look at that and say, this is a business. This has been operating with roughly this many employees for several years. It gives the IRS a lot of confidence that this is, in fact, an actual business. With a newer business, a recovery startup, right, they're only going to maybe have 941s for part of 2020, all of 2021, et cetera. So I think that's an area where the government's going to look hard, because there could be a lot of fraudulent claims, right? I started this restaurant after this law was passed, and it failed, but it was in operation during the, that's the kind of stuff that the government could look at hard. But of course, right, there are plenty of legitimate businesses that started during COVID and continue to operate this day, and they should not be afraid to go claim this credit if they're eligible.
Got it. That's helpful. So just a final question for you. So if someone wants to work with Stenson Tamaddon, they're very interested in about this, maybe want to learn more. What's the best way to contact you or your firm going forward after this?
Sure. They should go to our, and I saw a question pop up from Lisa, and it said, what if the business was not started before 2021? I think was the question.
Yeah, that's correct.
So you had to be operating, I think I understand this, Lisa, but I just want to make sure. If you started the business in 2022, then you wouldn't be able to claim the credit, because you wouldn't have filed any 941s in 2021, and you weren't operating a trade or business in 2021. You have to claim this credit. You have to have had an operational business in 2020 or 2021. But if you would like to speak with our company further about this, one of the best ways to contact us is www.stentam.com, right through our website. And if you refer to this webinar, we will note that, and it might go ahead and get you a 10% discount off of your fee if you contact us within a week of this. And typically we do operate on a contingency fee basis. There's one more question here, which I'm okay with taking if you are, Mark.
Yeah, go right ahead, please.
All right. So Kristen asked, EIN formed 4/5/21 and open 6/8/21. Could we claim? I don't have enough information to give you a definitive answer, but what I can say is you could qualify as a recovery startup if you had less than 1 million in gross receipts during 2021. You had W-2 employees during, it looks like, maybe the third and fourth quarter of 2021. So potentially you could, if you qualified as the recovery startup, there's a 50,000 per quarter credit cap, right? And so, and it's still the 7,000 per employee on 10,000 wages. If they had less, it's prorated.
So it sounds like potentially yes, depending on other factors that aren't listed here. Okay.
Yes. Mm-hmm.
Great. Well, we're going to be making, there's a lot to think about here for folks, and I'm guessing some of them, frankly, like me, will come back and listen to parts of this again, just to consider what's the value of this program and what's the opportunity. We'll be making this recording available after the fact here. And just before we wrap up, I'm just going to plug the fact that, Hint Health is always trying to bring information like this to basically help our clients and help them in terms of ways and valuable opportunities they might not otherwise be aware of. We also have our Tech Docs chat. We have other live streams, and clearly we bring everybody together at Hint Summit in September in San Diego. So appreciate everybody joining. Mike, thank you so much for sharing your knowledge here today. Greatly appreciate it, especially if this program can help some of our practices. And other than that, I hope everybody has a great day.
Thank you, Mark.
Thank you. See you later.